cleaning up the record on that.
You're welcome.
Please be seated. Morning, everybody. Mr. Piazza, you may proceed.
Defense rest, Your Honor.
All right. Ms. Kozlowski, you may begin with your closing statement.
Thank you.
I think we're gonna get you going real soon here.
Hello, there we go. Good morning, everyone. Welcome back. This is my first chance to talk to you during closing arguments. Defense, after I finish, gets a chance to give their closing argument, and then I get a chance to do a rebuttal. Because as I've said several times, this is my burden to prove this case, so I get to talk to you twice today. I want to talk about the evidence that we heard yesterday. We heard from Lamarie and her sister, Deshauna. They testified very differently, didn't they? Deshauna admitted yesterday she didn't even want to testify, but she did it. You all agreed with me during jury selection that various things can affect how someone testifies, and you all agreed it's also uncomfortable to talk about a sexual experience in a room full of strangers. You all agreed to judge the witnesses fairly. First, I want to talk about Lamarie. She is 10 years old now. Back on June 22nd of 2019, when she comes up from the basement that day and they call her mom, she was 8 years old. She said she thought she was going to the basement because she got in trouble. She thought she was going to get a whooping. But that didn't happen. Like many times before, the defendant touched her inappropriately. He tried to stick his penis in her vagina like he had done before. She said that it hurt. Now, as jurors, you're allowed to consider circumstantial evidence and use your common sense. If he tried to stick it in her vagina and it hurt her, doesn't it make sense that there was some penetration, if even a little? Penetration is penetration, no matter how slight. It doesn't make sense that it would hurt her if he only rubbed it on her, as he said he did. And also, the same nurse testified that one day after the assault, when she did that exam on Lamarie's labia was extremely red, irritated, and painful to the touch. And I asked Lamarie, she said she did not shower, she did not scrub herself after the assault, she waited. The only evidence in the record to explain the redness to her vagina the day after the assault was the defendant trying to stick his penis into her vagina. Again, you're allowed to use your common sense. I asked the same nurse about injury to the anus because she didn't detect any. She said if there wasn't deep penetration, there may not be any injury. She also said that it's possible if there was an injury, it could have healed. And I told you in the very beginning of this during jury selection, there is no DNA in this case. You heard yesterday from the same nurse why there is no DNA. The same nurse testified that they don't do DNA swabs on children. Lemarié also testified that he stuck his penis in her anus, or her bottom, as she called it. She said that also hurt. And even more so, she testified that he stuck his penis in her mouth. He made that little girl you saw testify yesterday perform oral sex on him. She even described seeing white stuff. She described him cleaning it up with a towel. And remember, she's only 10, so this all happened before she was 13. She testified yesterday she thought the first time something happened, she was 4. And in 2015, she turned 4. We also heard her talk about the videos that she saw. She said they were naked men and women touching each other. I asked her, where were they touching each other? She said where the bathing suits are, but she said they were naked, it was on a tablet, and he said, watch this. Now let's talk about when Lemarié comes upstairs. You heard from Deshauna yesterday. She said when Lemarié came upstairs, I said to her as a joke, I know what you were doing down there. And she said the look on Lemarié's face, she knew something bad had happened. And it was Deshauna who made their brother leave the room so Lemarié could tell what had happened. Lemarié herself had no plans to tell their mom on that day. It was Deshauna acting as a protective sister. She said, we're calling mom right now. And remember, this had also happened to Deshauna. If she wouldn't have taken the initiative that day to call their mom and made Lemarié tell what happened, who knows how long that could have gone on. Now let's move on to what we heard from mom, Mahogany Jakes. She was at work, like any other day, and Desi Henderson was home with the children. The girls call her and tell her what happened. And when she talks to Desi, when she confronts him, he deflects. He puts the blame on 8-year-old Lemarié. He says, well, she took it out. He tells the mom of an 8-year-old that she came onto him. Then when she continues to confront him about what really happens, he says, I just rubbed it on her. I didn't put it in her. He says, I effed up. I effed up. And she says, no, you're an effed up person. She did what any concerned mom would do next. She called the police. She took Lemarié and Daisy to the hospital. And I asked her also, did Lemarié take a shower? Did she take a bath? She said, no, I wouldn't let her. And I asked Mahogany Jakes, the mom, how old is the defendant? She said 50. 2 years ago, when this was reported, he would have been 48 years old. He is 40 years older than Lemarié when he did this to her. Think about that. Now, again, this is my chance to give a closing argument. Mr. Piazza gets a chance to give his, and then I get a chance to get a rebuttal. Thank you.
Closing argument, Mr. Piazza.
Thank you, Your Honor. Morning, ladies and gentlemen. What the government just did is give what's referred to as closing arguments. On behalf of Mr. Henderson, I'm given the privilege and opportunity to give remarks to you at this particular time. Please remember that at the conclusion of my remarks, prosecution, since they have the burden of proof, will be able to say something again. So this is the last time I'll be able to talk to you. To start off with, I'd like to thank you. Thank you for your time and your patience in being in this particular case. For without you, criminal justice system could not work at all. What we have here is soon to be 12 people acting as a shield against an accusation and liberty and the individual. You are the jury. You stand and act as a shield between the government and my client. For you are not puppets of the government. You're independent, and that's what the system's built on. And again, I'd like to thank you for your time in this matter. It's only 2 days. Unlike places like California, where you read about cases that last 6 months at a time, most trials only last 2 or 3 days. So even though this is a very short trial, it's very, very important. It's important to Mr. Henderson, but it's also important to you because you're acting and doing your civic duty, being part of the criminal justice system. Now, during jury selection, we asked a lot of questions, and I asked a lot of questions, but we tried to get people who could be fair and honest and just to sit in this particular case. You are the conscience of the community. You stand for them. You did make a promise that you keep an open mind. So if you've made up your mind already, you violated that oath. Please set that aside. Because you haven't heard all the arguments. You haven't heard the instructions the court's going to give you. You haven't heard your fellow jurors talk about this case. But also during voir dire, you also promised you wouldn't let passion overcome objective look at the case. Yes, the charges are criminal sexual conduct. Yes, the accusation is dealing with a child. That creates passion and emotion in anybody. But you are the jury. You must set that emotion aside and look at the fact or lack of facts objectively. During voir dire, we talked about several concepts. And one of the concepts, and the court's going to tell you, give you definitions, is the presumption of innocence. Right now, Mr. Henderson, as he sits right there, is presumed to be innocent. And we talked about during voir dire that we don't talk about presumption of innocence around the dining room table. What does that mean? Look at Mr. Henderson. If that was your brother, your sister, your cousin, a friend of yours, you say, I don't believe the accusations. That's the attitude that you must look at Mr. Henderson right now. You don't believe the accusation. The old Missouri, show me. And it's up to the government, that table right there, that has a burden of proof. We don't have to prove anything. They have the burden of proof. And that burden of proof is proof beyond a doubt based on reason. During voir dire, I used the examples of the scales of justice, the various burdens of proof. In a civil case, when we talk about money, burden is by a preponderance of the evidence. And that means slightly one way or the other. Under some circumstances, the burden of proof on one party is by clear and convincing evidence. And that's a heavy burden. But when the government comes in and make an accusation against one of its citizens, we require them to prove that case beyond a doubt based on reason. And that is the heaviest burden of all. What does that mean? Prosecutor in their opening statement said, well, if you're buying a house, you might think about things. No, it's even more important than that. I discussed with one of your former jurors that was excused. If a loved one of yours was taken to the hospital, the doctor comes out and says, excuse me, but we're going to have to cut off the right leg to save their life. You'd want a second opinion. You want to make sure that that is the right thing to do before you agree to that. That is the mindset. That is beyond a doubt based on reason. And you people, you're reasonable. You didn't check your reasoning at the door. If you have a doubt and you're a reasonable person, that's a reasonable doubt. If you have a different doubt, that's a different reason. Every one of you could have a different reason for a doubt. Doubt can come from the evidence. It can come from the lack of evidence or the unsatisfactory nature of the evidence. If you sit down and talk to each other and say, well, I wonder about this, doesn't that in and of itself create a doubt based on reason? If there's unanswered questions, that's a doubt. You're the ones that decide the facts of this case. You decide where the truth is and where lies are. You decide where justice is. For if you think maybe Mr. Henderson's guilty, that's a not guilty verdict because it's not proven beyond a reasonable doubt. Perhaps he's guilty. is not sufficient. Probably he's guilty is not sufficient because you cannot convict on conjectures, speculations, or maybes. The issue becomes, is it proven beyond a doubt based on reason or not? And not equals a not guilty. The court's going to instruct you on what the law is. There's multiple counts of criminal sexual conduct in the first degree, 3 counts. There's what referred to as a lesser included of attempted criminal sexual conduct in first degree. Listen to the court when it gives you the instructions. There's also 1 count of distributing sexual explicit material to a minor. But it doesn't matter what the counts are. For the government hasn't proven that it occurred. You decide on credibility. You decide whether or not you believe a witness or not. We talked about voir dire. Can children lie? Yes. What do you do to determine whether or not somebody is lying or not? The court's going to give you some parameters of what to look for or look at. One of the things we talked about during voir dire, one of the things that the court's going to instruct you on is whether or not the person has a motive to lie. We're going to get into that in just a few minutes. But also during voir dire, we talked about, Mr. Henderson, we're not asking you to take Mr. Henderson home for dinner. He may not be a person you like because he whoops his stepkids. He's used a belt. Might not be appropriate, but he's not accused of that. Is that a reason for these kids to lie to get back at him? Is that a motive? Is that an incentive for them? Didn't at least Lamarie said that she wanted her mom to get back with her dad because she didn't like Mr. Henderson, didn't like it when he yelled at her, didn't like it when he whooped her? All of a sudden, he's out of her life because she's making this accusation. The sister, the Me Too, listen to how she testified. How howl did it sound to you? Again, doubt can come from the evidence, lack of evidence, or the unsatisfactory nature of the evidence. The court was going to instruct you that, yes, prosecution does not have to show any corroborated evidence. But as reasonable people, wouldn't you like to hear some? They introduced the nurse, what's referred to as a SAY nurse, to look for physical evidence. Did they find any physical evidence outside of a redness to the vagina area some 24 hours after the accusations made? Now let's be real, ladies and gentlemen. This young lady is saying this occurred, well, which story you want to believe, since she was 4 years old, every week or every day for 4 or 5 years. And yet, the same nurse found no bruising, no lacerations, no contusions, hymen's intact. Nothing, remarkable about the rectum area. There's supposed to be anal and vaginal penetration for 4 years on a daily or weekly basis, depending on which story you want to believe or listen to, and not one physical evidence. A reasonable person would ask those questions. A reasonable person would want answers. Let's take a look at Lamarie Jones. On June 22nd, 2019, it was her sister who told on her, says she is acting up. Mr. Henderson, or Desi as she called her, said her sister refused to call him dad as their mother wanted them to. Shows you that relationship off the get-go. Says Lamarie is acting up. She needs to be punished. Her sister was the one that sent her down to the basement to be punished. Lamarie says, I do not want to be punished. And lo and behold, she comes up with this statement, this accusation, and guess what? Everybody forgot about punishing her for what she did. What did she say? Originally, she said, he tried to put a penis inside me, and he put his penis inside my bottom. Well, she's talked to various CAN councils, CPS worker, Child Protective Services worker, police. And it goes from an incident there to, having it done 4 or 5 years, from either a daily basis, which she testified to at a prior hearing, to yesterday to, it was a weekly basis, to adding the fact that she even admitted she never said anything about the penis in the mouth until a year after the alleged incident, after the first talking. The movie, she said originally a year after the incident, a year ago, said, well, it was 2 women. Now she comes to you and asks, well, there's another movie that had men and women in it. She keeps adding to the story. What does that tell you? It tells you she's making it up. And how did she testify? What happened next? And she looks up and thinks about it as if the whole thing's rehearsed. You make a decision on credibility, but looking at credibility, you make a decision how somebody testifies, what they say, what they didn't say. And would press for details. Yes, she's only 10 years old. I'm sure the government's going to come up here. Well, she's only a little girl. But details, any details. What was he wearing? I don't know. You said this happened, when you were 4. What, day of the week? I don't know. Well, that's fine. What month? I don't know. What year? I don't know. What season was it? And reasonable people would ask these questions. This supposedly occurred for 4 or 5 years on a daily or weekly basis, depending which story you want to believe, and not one witness. 7 brothers and sisters. And Lamare says nobody's seen anything. Well, her sister comes and says, well, yeah, I saw it. Well, what'd you see? Well, one day she was sitting in his lap. Yeah, okay. A kid sits in their stepdad's lap. The other time was, he was putting some ointment on. Obviously didn't raise any concern at the time because she didn't say anything. 7 brothers and sisters. And now one supporting, say, oh, I saw them together, naked. I saw this. But what the witness did say, her sister did say, yes, Lamare got caught with her pants down, naked from the waist down at one time. And Mr. Henderson wasn't even in the house. No witness, no outcry. And Lamare even said she was taught in school, good touch, bad touch. Bad touch, tell somebody. Did she tell anybody over those 4 years? Did she tell a teacher? No. Tell her mother, who she says she confides in and she loves. Did she tell her? No. Tell a police officer, a neighbor, a sister, a brother. 4 years in a house full of kids. Nobody sees or hears anything. Does that raise a little flag in your head? Say here, wait a minute. This doesn't make sense. Only when she is in trouble and feared getting a whooping does she make this accusation. And what did she say about Mr. Henderson? She hates him, doesn't like him, because he yells at her, because he whoops her, because he used a belt against her. Even she said her and her siblings wanted their mother to get back with their dad, and to be able to do that, they had to get rid of Mr. Henderson. The sister said, refused to call him dad as the mother wanted to, called him Des. Does that show an attitude? They wanted to get rid of him, and guess what? She came in here to testify just to do that. One might think, and the government might argue, well, why make this type of accusation? Well, listen to what the mother said to the doctors at the hospital. She admitted, well, my other children were sexually molested by somebody else before. Gee, there's a story planted in these kids. Don't want somebody around, let's just make an accusation. It worked before. Make an accusation, the problem goes away. That's exactly what we have here, ladies and gentlemen. We have no physical evidence outside of the sane nurse, and we talk about her in a few minutes, outside seeing some redness and touch, some 24 hours afterwards. No torn clothing, no fluids, no semen. They've talked about the fact that this movie was on an iPad or cell phone. Did the police ever execute a search warrant to take a look at and search the iPad or cell phone to see whether or not it actually exists? The same nurse, what they do, they look for physical evidence. She found none outside the redness. Look for pubic hairs, foreign pubic hairs, found nothing. Same nurse, Ms. Gillespie, says, well, the redness could come from multiple things other than sexual encounters. Even Lamarier said that she, when she bathes, she scrubs herself vigorously in that area. Desiree Sharp. Let's take a look at what she says. And please pay attention to the court. Of course, going to give you some instructions about what's referred to as other acts and how to treat that. But let's take a look at Desiree Sharp. Her sister makes the accusation, but she set the thing in motion by asking Mr. Henderson to punish her because she was acting out. She goes to the CAN council herself and is interviewed. Did anything happen to you? No, not at all. She talks to Child Protective Services, was interviewed by them. Did anything happen to you? Nope, nothing happened to me. Nothing. A year later, she goes back to the CAN council. Yep, it happened to me too. Trying to buttress her sister's testimony. After getting the opportunity on several occasions to say things, declined doing so. But the case is still going a year later, so she decides, hey, I'm going to help my sister out. I'm the one that got her in trouble to begin with. She even gave you a motive for her to lie. She didn't like Mr. Henderson. He says he's mean to the kids and to her. He'd whoop them, whoop their butts. He'd use a belt. She herself says, my mom told me to call her dad, and I wouldn't do that. He's Des to me. Now claimed having sex daily with him. Where's the physical evidence of her? Where is a sane nurse that did an examination on her? Sounds like she is trying to set Mr. Henderson up to get rid of him as well. And what's interesting to note with Desiree Sharp, she says it happened for 4 or 5 years. Gee, that's similar to what Lamarier is saying. She said here in court from that witness stand that it ended in 2015. It ended in 2015. The mother testified that Mr. Henderson didn't even move into the house till 2015. So how can Mr. Henderson be having sex with Ms. Sharp while he was living with her for 4 years when he wasn't even around? He didn't start dating their mother till 2014, moved in 2015, according to the mother. Wait a minute. Something is not right here. And again, asking her details. When? When did it start? When did it end? What year? 2015. What month? I don't know. What season? I don't know. What was he wearing? I don't know. I'm sure the government's going to come up and say here, well, do you expect kids to remember all these details? How about some details? Any details? If you notice, they had their story here, which sounds rehearsed, and when asked about any details, all the answers was, I don't know, I don't know, I don't know, simply because it never talked about, or rehearsed it beforehand. Let's take a look at Miss Jakes, the mother. Claims Mr. Henderson said all this stuff. She's mad at him. Kids make accusations. She's going to take his side or her side. She's going to help her kids out. Human nature. But again, what's important about her testimony is she told the doctor at the hospital that her kids were molested by another person. So there's where everybody gets the story. What did the police do in this case? What didn't they do? They took the Lamare's underwear. Okay. Was it sent to the lab for analysis? Was there any seminal fluids? Was there anything in there? Oh, wait. We don't know. We don't know what they did with the underwear. They weren't in here telling you what they did with it. Wouldn't you like to know? They were told that, according to Lamare, Mr. Henderson used a towel to wipe himself off. Did they go back and try to get the towel to see if there's any seminal fluids or semen there? Wouldn't you like to know? Oh, Lamare says that, I watched these movies. Did they get and seize any tablets or cell phones? Wouldn't you like to know? See whether it's true or not? They didn't do any of that stuff, and reasonable persons and reasonable people, before they would even consider a conviction, would say, wait a minute, we want to see the evidence. That's why the doubt could come from the evidence or lack of evidence. They didn't do their job. Tammy Gillespie, same nurse. What do you look for? Look for bruising. You find any? No. You look for tearing. Find any? No. Look for scars. Do you find any? No. Of all these weekly or daily sexual activity, according to Lamare, for 4 years, the anus was unremarkable. The hymen was intact. That in and of itself should tell you something about this story. That in and of itself will have you come back with a not guilty verdict. She found redness, but it could come from a lot of things, not necessarily sexual in nature. And the redness that she talked about apparently was found 24 hours after. Note that this supposedly occurred in the afternoon of the 22nd, and she wasn't seen by the same nurse until the 23rd. What happened in between? Well, I didn't wash myself. How do we know? Is redness going to last that long? Or not? Nothing remarkable about the anus or vaginal area. The hymen's intact. Yet, Lamare, as well as Ms. Sharp, claims sexual abuse for so many years and no physical evidence. I asked Ms. Gillespie, can you conclusively say that there was a sexual assault here? And she said, no. No. That's another doubt. You could just come back and say, here, not guilty. Lamare Jones gets in trouble, goes to get a whooping, cries wolf. Everybody else forgets about her being in trouble. There's a stepfather, not necessarily married, but acting like a stepfather, disciplinarian. Not a good situation. Kids don't like him. Kids revolt. That's not my father. We don't want him here. Ladies and gentlemen, this case is loaded with doubts. Take a look at it. Take it apart. Don't step back and gloss over all these questions, because these are serious questions that need to be answered by the government, and it's not. Kids have a motive to lie, lack of physical evidence. The story keeps changing, getting bigger and bigger. It doesn't pass the smell test, ladies and gentlemen. It's that simple. You have a tremendous responsibility, ladies and gentlemen, because you're going to be called upon to consider my client's fate. It's a grave responsibility. And whatever your verdict is final. Because it leaves no room for error, no room for speculation, no room for conjecture. Whatever your verdict is, you go home. Don't render a verdict that you may feel sorry for tomorrow. We talked about during voir dire about reading, about people being in prison for so long, only to find out, something went wrong, or new evidence, or testing, and they've been so many years in prison, and it's sad. I think one of you talked about it during voir dire, saying here, felt sorry for the person. Something's got to be done. It's done right here, right now. For you have to take a look at the facts. You have to make a determination. Because now is the time to question the government. Now is the time you must be certain. Now is the time you must look at the facts or lack of facts meticulously and conscientiously. Please listen to your fellow jurors. Listen to your own heads. Listen to your heart. Looking at this objectively. Asking the questions that I've raised here that cannot be answered. Because the government has failed its duty. Simply, your job is to say, government, you're proving it or not. And by not proving it, find not guilty. The government has the last word, ladies and gentlemen. I just want to ask you to think about the questions I've raised, the doubts that are there. Do not ignore those doubts, ladies and gentlemen. Mr. Henderson is counting on your common sense and your reason for a proper verdict. And in this particular case, proper verdict is not proven, not guilty. Thank you.
Rebuttal, Ms. Kozlowski.
Hello again. You heard that this is a very important case for Mr. Henderson. That's true. It's also a very important case for Lamarier. She's 10 years old. Mr. Piazza asked her yesterday if she was penetrated. She said she didn't know what that meant. She's 10. She has redness, irritation. It's painful to the touch. She knew that it hurt. She may not be able to use the word penetration, but use your common sense. That's what happened here. He says she's making this up. Why? To get out of a whooping that she's had many times before. Never made anything up then. She testified yesterday. She thought that she would go to jail for telling. She thought she would get in trouble for telling. Now, these crimes aren't usually committed with witnesses present, but there's more than just her statements. He says there's no other corroborating evidence, but there is. The look on her face when she comes upstairs. Deshauna says, I know what you were doing down there. The look on her face, that was enough. Deshauna knew something had happened. I asked her yesterday, was he ever nice to you? Did he ever play games with you? She said, yeah, he did that. He's not mean all the time. He mentions mom at the hospital saying her other children were assaulted. There's no evidence mom planted this story. There's no evidence mom wanted him out of the house. She was angry when she found this out. She wasn't happy. She wasn't relieved. This wasn't what mom thought was happening, what mom wanted done. She wasn't excited to discover this. The same nurse. I asked her if the redness that she saw could have been caused from scrubbing the vagina. She said no, not the way she saw it. Plus, Lamarie didn't bathe. She waited. The same nurse also said injury may not be present if there was not deep penetration. He says they don't remember any details of any of these instances, but they do. They remember what happened to them. They remember where it happened. They remember it hurt. They remember things that he said to them. Remember, Deshauna said yesterday that he would show her how a real woman does it. Also, we have Mr. Henderson's statements himself that he made to the mom. He says, I effed up. He admits to having sexual contact. If this was made up, why make those statements? Use your common sense. Again, this is a very important case for both sides. I won't dispute that at all. And before I end, I want to leave you with this. These girls didn't have a calendar. They weren't writing down what was happening to them on a daily basis. We talked in voir dire about why someone may not report right away, why someone may have some trouble remembering details. You all agreed. It could be because it happened so many times. Maybe they thought they would get in trouble. I want to remind you of what Lamarie said. I asked her, what did you think would happen when you told? She said, I thought something would happen. I thought maybe he would get in trouble and go to jail. I thought I would also get in trouble and go to jail with him. A 10-year-old had those thoughts, all because of what the defendant did to her for years and years. I ask that you go back to the deliberation room, you have an open and honest discussion with each other, and you find the defendant guilty on all counts, because we've proven this case beyond a reasonable doubt. Thank you.
Members of the jury, the evidence and argument in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember, you've taken an oath to return a true and just verdict based on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that you may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty, unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence. You must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyer said that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to witnesses and my questions to the witnesses are also not evidence. You should only consider these questions as they give meaning to the witness's answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. We should not use any personal knowledge you may have about a person, place, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think the testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. A, was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? B, did the witness seem to have a good memory? C, how did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? D, does the witness's age and maturity affect how you judge his or her testimony? E, does the witness have any bias, prejudice, or personal interest in how this case is decided? F, have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree. You must decide which testimony you accept. You should think about whether the disagreement involves something important or not, whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that the witness deliberately lied about something that is important in how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things, but told the truth about others, you may simply accept the parts you think is true and ignore the rest. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all the evidence in the case. You may consider the statement in deciding the facts of the case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if you see a person come in from outside wearing a raincoat, covered with small drops of water, there will be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You've heard evidence that before the trial, a witness or witnesses made a statement or statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. The defendant's intent may be proved by what he said, what he did, how he did it, or by any of the facts and circumstances in evidence. You heard that a lawyer or a lawyer's representative talked to one of the witnesses. There's nothing wrong with this. A lawyer or a lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. For a witness who is a young child, a promise to tell the truth takes the place of an oath to tell the truth. You've heard testimony from a witness, Tammy Gillespie, who was giving her opinion as an expert in the field of sexual assault nurse examinations. Experts are allowed to give opinions in court about matters they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts she gave her opinion, whether those facts are true. You should also think about the expert's qualifications and whether her opinion makes sense when you think about the other evidence in the case. You've heard testimony from a witness who is a police officer. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. In count 1, count 2, and count 3, the defendant is charged with the crime of first-degree criminal sexual conduct. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, as to count 1, that the defendant engaged in a sexual act that involved entry into the complainant's anal opening by the defendant's penis. As to count 2, that the defendant engaged in a sexual act that involved entry into the complainant's vaginal opening by the defendant's penis. And as to count 3, that the defendant engaged in a sexual act that involved entry into the complainant's mouth by the defendant's penis. Any entry, no matter how slight, is enough. It does not matter whether the sexual act was completed or whether semen was ejaculated. Second, that the complainant was less than 13 years old at the time of the alleged act. If you find that the defendant is guilty of first-degree criminal sexual conduct under count 1, count 2, and count 3, then you must decide whether the prosecutor has also proven the following: that the defendant was 17 years of age or older when the offense occurred. Under count 1, count 2, and count 3, you may also consider the less serious crime of attempted first-degree criminal sexual conduct. To prove that the defendant attempted to commit this crime, the prosecutor must prove the following elements beyond a reasonable doubt. First, that the defendant intended to commit first-degree criminal sexual conduct, which was previously defined for you. Second, that the defendant took some action toward committing the alleged crime, but failed to complete the crime. It's not enough to prove that the defendant made preparations for committing the crime. Things like planning the crime or arranging how it will be committed are just preparations. They do not qualify as an attempt. In order to qualify as an attempt, the action must go beyond mere preparation to the point where the crime would have been completed if it had not been interrupted by outside circumstances. To qualify as an attempt, the act must clearly and directly be related to the crime that the defendant is charged with attempting and not some other objective. In count 4, the defendant is charged with disseminating sexually explicit material to a minor. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant knowingly displayed or disseminated sexually explicit visual or sexually explicit verbal material to the complainant. Second, that at the time the complainant was less than 18 years of age. As used in previous instruction, display means to put or set out to view or to make visible. Disseminate means to sell, lend, give, exhibit, show, or allow to examine, or to offer or agree to do the same. Sexually explicit verbal material means a book, pamphlet, magazine, printed matter reproduced in any manner, or sound recording that contains an explicit and detailed verbal description or narrative account of sexual excitement, erotic fondling, sexual intercourse, or sadomasochistic abuse. Sexually explicit visual material means a picture, photograph, drawing, sculpture, motion picture film, video game, or similar visual representation that depicts nudity, sexual excitement, erotic fondling, sexual intercourse, or sadomasochistic abuse, or a book, magazine, or pamphlet that contains such a visual representation. To prove the charge, it is not necessary that there be evidence other than the testimony of the complainant, if that testimony proves guilt beyond a reasonable doubt. To prove the charges, the prosecutor does not have to show that the complainant resisted the defendant. The prosecution has introduced evidence of acclaimed acts of sexual misconduct by the defendant with a minor for which he is not on trial. Before you may consider such alleged acts as evidence against the defendant, you must first find that the defendant actually committed those acts. If you find that the defendant did commit those acts, you may consider them in deciding if the defendant committed the offenses for which he is now on trial. You must not convict the defendant here solely because you think he is guilty of other bad conduct. The evidence must convince you beyond a reasonable doubt that the defendant committed the alleged crimes, or you must find him not guilty. The prosecutor must also have proved beyond a reasonable doubt that the crimes occurred within Saginaw County. Time, however, is not an element of the crime of criminal sexual conduct. The prosecutor does not have to prove the date or time of the offenses beyond a reasonable doubt. When you go to the jury room, you'll be provided with a written copy of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way, and that everyone has a fair chance to be heard. During the deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them. Keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you are wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. I've already given you instructions regarding lesser offenses. As to any count which includes a lesser offense, you must first consider the principal offense. If you all agree that the defendant is guilty of that offense, you need not consider the lesser offenses. If you believe the defendant is not guilty of the principal offense, or if you cannot agree on that offense, you may consider the lesser offense. It's up to you to decide how long to consider the principal offense before discussing the lesser offense. You may go back to consider the principal offense again after discussing the lesser offense if you want to. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, please submit them in a sealed envelope to my law clerk. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my law clerk. It's not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all the exhibits that have been admitted, just ask for them. In this case, there were none admitted. When you go to the jury room, you'll be given a written copy of the instructions you've just heard. As you discuss the case, you think about all my instructions together as the law you are to follow. The defendant is charged with 4 counts. These are separate crimes, and the prosecutor is charging that the defendant committed all of them. You must consider each crime separately in light of all of the evidence in the case. You may find the defendant guilty of all or any combination of these crimes, guilty of a less serious crime, or not guilty. I've also prepared a verdict form for you listing your possible verdicts. On the verdict form itself, it says count 1, first-degree criminal sexual conduct, penal or anal penetration. Your possible verdicts are not guilty, guilty of first-degree criminal sexual conduct, guilty of lesser offense of attempted first-degree criminal sexual conduct. Once you answer this particular part of the verdict form, you go on to the second part, and it's self-explanatory on there. Count 2 says first-degree criminal sexual conduct, penal vaginal penetration. Your possible verdicts are once again not guilty, guilty of first-degree criminal sexual conduct, guilty of lesser offense of attempted first-degree criminal sexual conduct. Count 3 says first-degree criminal sexual conduct, penal oral penetration. Your possible verdicts are once again not guilty, guilty of first-degree criminal sexual conduct, guilty of lesser offense of attempted first-degree criminal sexual conduct. Count 4 says disseminating sexually explicit material to a minor. Your possible verdicts are not guilty or guilty of disseminating sexually explicit material to a minor. Once you reach a verdict on each count, your foreperson will sign and date the verdict form. I'd like to see counsel at the bench, please. Ladies and gentlemen, that concludes formal instructions, and at this time, we will reduce the number of jurors who would decide this case. One of you will be excused by random draw. If your name is drawn, just please remain seated.
Juror number 9, Christopher Frank.
Mr. Frank, even though you've been excused at this time, I will still ask you not to discuss the case among anyone until such time as a verdict has been rendered, because as an alternate, should something occur, you will be called back to continue deliberations, okay? So until that's reached, do not discuss the case with anyone still, all right? At this time, you can swear the jurors,
Please stand and raise your right hand.
including you, Mr. Frank.
You and each of you do solemnly swear that you will well and truly try the issues joined in the cause now here pending, and unless discharged by the court, a true verdict rendered, and that you will do so solely on the evidence introduced and in accordance with the instructions of the court, so help you God.
All right, commence the oath to the law clerk now.
Do you solemnly swear that you will, to the utmost of your ability, keep the persons sworn as jurors in this trial in some private and convenient place, that you will not suffer any communications to be made them orally or otherwise, that you will not communicate with them yourself orally or otherwise except by order of the court, or to ask them if they have agreed upon their verdict until they shall be discharged, that you will not, before they render their verdict, communicate to anyone the state of their deliberation or the verdict that they have reached and agreed upon. So help you God. I do.
At this time, ladies and gentlemen, you may go to my law clerk and begin your deliberations.
All rise for the jury, please.
Please be seated. Records should reflect the jury is not present at this time, and after the court had read the instructions to the jury, had counsel approach the bench to see if there were any additions, deletions, objections, or corrections. Ms. Kozlowski, I believe you had none.
That's correct.
Mr. Piazza, I believe you had none.
None other than those previously stated on the record about the lesser included.
All right. Anything else for the record, Ms. Kozlowski?
No, Your Honor.
Mr. Piazza?
Not for the record, Your Honor, no.
Okay. I would ask both counsel, it's about 10 to 11 now. And so if you're going to stick around, that's fine. If you're going to leave a cell phone number where my office can get a hold of you, all right?
I'm going to stay here until at least lunch. If the court sends the jury out to lunch, if they could just inform us so we can leave at that time too.
Do you wish to be present if I send them out to lunch or just?
Just,
Okay.
just inform.
All right, I'll let you both know that then without